pious, more honest, more straightforward, more responsible. Ramadan should not weaken you to be going against your own work. Honorable members, the Assembly now resumes. So for the continuation of our business, I will resolve the Assembly in the Committee of the Whole House to continue our business. The Assembly is now resolved into the Committee of the Whole Assembly. Honorable members, the Assembly now resolves into the Committee of the Whole House. And we will start from where we stopped. If you remember, we stopped clause 6. Yes, that's where we stopped. Is Honorable Member for Nyani Jarang? Okay, you can then guide us. Okay, go ahead.
Thank you.
Clause,
Clause 7, functions of the Directorate.
It is proposed that Clause 7, functions of the Directorate, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 8, functions of the Chief Registrar of Registrable Events.
It is proposed that Clause 8, functions of the Chief Registrar of Registrable Events, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 9, Deputy Chief Registrar.
It is proposed that Clause 9, Deputy Chief Registrar, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 10, Regional Registrar.
It is proposed that Clause 10, Regional Registrar, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 11, National Civil Registration System.
It is proposed that Clause 11, National Civil Registration System, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 12, Automated Database.
It is proposed that Clause 12, Automated Database, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 13, Registration System Data.
It is proposed that Clause 13, Registration System Data, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 14, Data Protection.
It is proposed that Clause 14, Data Protection, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 15, Interaction between the registration system and other information systems.
Honorable Member for Upper Salum.
On 15.2, it says the directorate shall, on the basis of registration system, provide personal data to other government information systems and may receive data from them. I propose that we add based on a predefined policy, because they cannot just allow data from other institutions to connect to their data without any kind of policy happening. That would be a big risk to do. So I have what I propose. Maybe I can bring it, you read it. No, please.
He is suggesting that we amend it this way. The directorate shall, on the basis of the registration system, provide personal data to the government information system, and may receive data from them based on a predefined policy. Honorable Minister? That's fine. Honorable members? So what should be added there is data from them based on a predefined policy.
Honorable Speaker. Chair.
Just a minute. Yes, who is there? Honorable member for.
Yes, Busumbal. I'm just want to know from the person who proposed it whether predefined policy will not be interpreted.
Yes. Normally, what happens is if you own a database or you own a system, you can allow others to connect to you, but the way others connect to you must be defined by yourself, and that's based on your security protocols, whether it's the network or whether it's actually building an interface between the two systems. Like, for example, the commercial banks, they're all connected at the level of the central bank, but there's a defined policy that they have to have. You have to have this, you have to have that, so that they can actually connect, and that would protect their own systems, which means they would have to define who's going to connect to me, how are you going to connect, based on the various security protocols. So they would have to define that. That's for them to protect their own system. Yeah.
Predefined policy. They have to generate a policy that would govern how these things are done.
If immigration wants to connect to their system for whatever reasons, they will have to tell immigration, you have to abide by these rules, whatever. Yeah.
I think that's fine. It is proposed that clause 15, interaction between the registration system and other information systems, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 16, registers.
It is proposed that clause 16, registrars, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 17, correction of errors in the civil marriage register.
Yes, yeah, there's a proposal. Thank you. The proposal is to have some little changes on the heading. That is, instead of correction of errors in the civil marriage register, it should read as correction of errors in the register. I'm confused. In the civil register of births and deaths. In the civil register of births and deaths. You delete marriage and add births and deaths. Of births and deaths.
It is proposed that clause 17, correction of errors in the civil marriage register, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 18, correction or cancellation of entries.
Yes, there's a
Yes.
proposal.
Yes, go ahead.
Yeah, first of all, the heading should, for correction or cancellation of entries, should for births and deaths should be added there, and it will read correction or cancellation of entries for birth and death. Then going forward at the sub clause.
No, let's get that correct.
All right, all right.
Correction, this is what, clause 18.
Yes.
You say correction, here we have correction or cancellation of entries.
Four.
Now,
You want to add
no,
there?
what I'm saying, what we have on the bill
Yes.
is correction or cancellation of entries.
Entries. We want to add
That
there.
should be corrected
Yeah.
to read correction or cancellation of entries for births and deaths.
Correct. Perfect. Then can I move on?
Just hold on. Correction 18. Correction or cancellation of entries for births and deaths.
Yes, sir.
Yes, go ahead.
Sub 6 and 7 should be deleted and repositioned on clause to clause 66.
When you reach there,
Yes.
let's first delete.
Yes. Yes, to be moved.
Clause 6 and 7 should be moved to clause what?
66.
Clause 66.
And it will be read like 4, 5.
Clauses 6 and 7, am I right? Clauses 6 and 7 of clause 18. Clauses 6 and 7 of clause. No, you move sub clause later. Huh? Sub clauses 6 and 7 of clause 18 be moved to clause 66, huh? To clause 66. Three and four where? There is no 3 and 4 of 66, see? No, what I'm saying is, you are moving 6 and 7 to 66. 66 has only 2 clauses. 1 and 2, though this these ones will be 1, 2, 3, and 4. Yes. Uh-huh. It is proposed that clause 18, correction or cancellation of entries, stand part of the bill as amended. No, that is the amendment. Yeah, correct. Stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes.
Clause 19, places of registration.
Yes. Thank you. Again, the heading, there should be an addition there for birth and death. Now it will read as
Places of registration for birth and death.
Yes, exactly. And that is it.
It is proposed that clause 19, places of registration, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 20, registration abroad.
Honorable, that's the care of the Health Committee. 19, if you look at your proposed amendment, 19 subsection 4, you propose an amendment. No more?
Yes, yes, no more, no more.
No more?
Yes, we want to capture it on the offenses clause later.
Okay. 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 So
Maybe.
all right, it is
maybe.
proposed. I've just put the question for 19, isn't it?
Okay, Chair, before you put it, maybe the legal people can help us. Maybe couch something before we read the offenses clause for, like for sub 4, in case of default of sub 4, what should happen to a private clinic?
Clause 19. A private clinic shall compile records of all birth and death certificates that occur in the private clinic and notify the regional registrar within 14 days of the occurrence of the birth or death. 19.4.
Penalty failure to section 19 of subsection 4, the fine shall be considered in the regulation. But what are you saying of section 19 sub 4? Okay.
No.
Yeah, you are asking them, but you have not made any suggestion.
No,
Yes.
what we agreed later on with the ministry is to not to actually limit it to the regulation, but we want to capture it in the offenses clause, whereas a private clinic happen to do the needful here, it can be captured in the offenses clause, because many of the births nowadays are happening in some of the private clinics, and they will not register them, they will not report them.
You mean for the various defaults
Yes.
or offenses?
Yes, exactly.
So
that it
this
can-
thing will capture them.
Yes.
But are they all the same type?
Yes, of course.
Because here
There-
you are only going to put
There
one.
are offenses captured on the.
No, what I'm saying is,
All
if
right.
you put it on the offenses, it may mean that all the other offenses, you have only one type of punishment for all of them.
We agree now is that the legal people will look at how to point it, because we want it also to be captured so that it will not fit only in the offenses section. So we are just asking that if the legal team can help us.
Not help when you have various offenses there and different categories. They cannot help you
Chair.
unless the offenses there look all similar.
Yeah, Chair.
Uh-huh.
I
Yes.
think even as in the offenses clause, clause 97, I think it suffices. Yeah, if you look at clause 97 sub 1A, sorry, let me read one. Subject to this act or any other relevant law, a person who is under an obligation to register a birth, death, marriage, or divorce fails to do so, do the registration, has a custody of register of birth, and this here, private clinics, they have custody of register of birth, death, marriage, or divorce, and losses or damages, the register, then, yeah, I think it's captured.
It's proposed that only the addition is for births and deaths on the heading. Yes. Honorable? Yes. So it is proposed that clause 19, places of registration stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 20, registration abroad.
Yes, we move the proposed amendment after consultation with the ministry. I think is not something which you know that is it doable or tenable. So we move. No amendment.
Registration abroad stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 21, registration where the place of birth or death is unknown.
It is proposed that clause 21, registration where the place of birth or death is unknown. Yes?
Yes, this is in relation to people that we cannot confirm when they were born or their parents. How are they going to handle that situation where the parents of the child is unknown? They just abandon it somewhere and then they go. I'm asking this question in relation to citizenship and in relation to stateless children as well.
Is it in relation to 21?
Yes.
Because here he's not talking about if your this thing is unknown. He's talking about place.
No, abandon. Here, if you check 2, where living
the
newborn
place of birth or death is unknown.
It's unknown, yes.
No, yeah, not.
And in fact, it's asking you to report.
Yeah, he's not talking about you. That may come in a subsequent one with a separate clause to deal with it.
No,
but this one.
No. Look at 2. No, wait. We are on the same thing. If you read 2C, a registration officer shall register the birth in the prescribed form. Therefore, I'm asking if the parents is found abandoned. Yes. C in the prescribed form. Yes. And the question I'm asking is, if the parents of this particular person is unknown, how are they going to register that person? Yes, whether you are a Gambian, non-Gambian, I'm asking in relation to stateless people.
It's a Gambian. That one you don't need to say, I don't know. You found him in the Gambia.
Yes.
His parents, birth alone does not qualify you, but you don't know the parents, you don't know the mother and the father. The birth will qualify you only to be a Gambian, no other place.
That is only applies to a it applies to newborn.
Yes. And the same thing, the same place, 3. And
no, because
and
see,
I'm told you look at 3 on the next page, where the date of birth
is unknown. Yes.
Have you seen it? Have you seen it? Does that take care of you?
You see, we've already defined child, and a child means a person below the age of 18 years.
Yes.
So,
no, what I'm saying is under current legislation, for you to be a Gambian, it's not only when you are born here, but one of your parents must be a Gambian. Huh? You can be born outside. If one of your parents is a Gambian, you are a Gambian. All right? Now that you have found a child in the Gambia, meaning born in the Gambia, you have found him in the Gambia. You have no other place to associate him with. You don't know the mother and the father. That is going to, which state, how can you say it's going to be a Nigerian or a this thing? You can only make it a Gambian. You register him. And he's found in your country. I think that's my only logic.
Yes, Chairman.
Yes.
Chairman, I think if you look at clause 21, registration where the place of birth is unknown or that is unknown. So it's now telling us that in the event you now found a child now, the clause 3 here tells you the modalities to go about it. Where the date of the birth of a child is unknown, the register of medical personnel certify in writing the date of the birth. A register officer shall enter the certificate into the register. No, he's exactly. He's not about nationality. He is concerned about nationality, but which you have answered. That if you don't know the mom and the father, but the child is found within the territory of Gambia, then it's automatic.
Huh? 43.
43, Schedule 1, entered in the register of birth. I, nationality of the mother.
I don't understand you.
Yeah, what I'm
43.
trying to, yeah.
What do you mean, clause 43?
43, so not 43, I mean Schedule 1, page 43.
Schedule 1, page 43, yes?
Yeah, that is pertaining to the parents. The option is there, where applicable.
Here, particulars to be entered in the register of birth.
Yes.
Date, place, and time of birth, sex of the child, full name or names and name of the child, full names, surname, birth, name, address, and confusion. Occupation of mother, and then the same thing of the father, and then marital status of the father, nationality of the child. Nationality of the child is his concern now. How do you determine that? That's what he's saying. That nationality of the child. Nationality of the mother. You don't know the mother. You don't know the father. The child is found in the Gambia. What is the nationality? I think that's your concern. I don't know where else you can ascribe the child.
Yeah. And when for the nationality of the father, where applicable.
Yeah, you know, nationality of the father is not known.
So that's what I'm trying to say.
The mother is not known.
Yes, I'm trying to say that is addressing that circumstance.
Okay.
Yeah. I think the mother also should have where applicable.
Yeah.
If we come to the schedule.
Yeah. That's correct.
Yeah, we should put where applicable for both mother and father.
Where, if you come to this schedule here.
Yeah.
You know marital status of the father, you mean?
Now, I mean, we have nationality of the father where applicable. So I'm trying to say we should also add under the mother also nationality of the mother where applicable.
Okay, where applicable is on the father.
Yes, only father. And a scenario may happen that we may not even know both mother and father's nationality.
Me, my problem, in fact, is I don't have where applicable.
Chair.
Where applicable to
Chair, we'll reach there. We'll reach there. Chair.
There is something omitted on mine. That's what I'm trying to confirm.
Okay.
You know, you have where applicable on yours, where completely spelled out, or just no. Yeah, for the father, I only have applicable. Where applicable is not there. Have you seen where applicable? It's cut. Yeah, this is what I'm saying. It's cut off. So that should be noted.
Chair, clarification. Chair.
Where applicable,
Yes, Chair. Yes. On the concern raised by the member for Upper Salom, I think his concern is addressed under clause 24, sub 3. If you look at it, it reads as where a newborn child of unknown parentage is found abandoned and his or her place of birth is unknown, a registration officer shall register the birth of the child at the civil registry of the area in which the child is found. Then continues the mother and so on and so on. I think it's captured. Honorable.
In essence, they are trying to make sure that you don't render anybody stateless. Yes. Cannot be stateless.
Thank you very much. The honorable member for Nyanija has addressed my point. That's what I want to raise, in fact. Yeah.
It is proposed that clause 21, registration where the place of birth or death is unknown, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 22, registration during extraordinary circumstances.
It is proposed that clause 22, registration during extraordinary circumstances, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 23, responsibilities of military authority.
It is proposed that clause 23, responsibilities of military authority, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 24, birth.
It is proposed that clause 24, births, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 25, persons responsible for giving notice of birth.
It is proposed that clause 25, persons responsible for giving notice of birth, stand part of the bill. Those in favor, please say aye.
Clause 26, duty of a parent.
Yes, Chair.
It is proposed that clause 25. Am I right? It's 25? Yes, 25. Persons responsible for giving notice of birth stand part of the bill. Those in favor, please say aye. Those not in favor, please say no.
Yeah, they are calling you.
Huh? You said what? Who is talking?
Go.
Wooly, what is the problem?
Who's coming in? Clause 26.
No. I don't know. You sometimes distract us too badly.
Clause 26, duty of a parent.
Clause 26, he's saying, you are here saying 6 days instead of 4 days. A person who does not comply with subsection 1 shall pay a registration fee of $500 instead of $2,000. This is 26, isn't it?
26, one also. Look at one. 60 days instead of 40.
But this is what I first read. I said 6 days instead of 45 days. 60 days, yes. And then 2, a person who does not comply with a fine of 500 instead of 2,000. That's what I read. So, but people must relate it. Clause 26 reads. Yeah, let's just relate it and then you all see. Yes, I'm coming to you. This is he's talking about 1. No, this is 61. 60. No, what I mean is your number 1 is 60 days. This is what I'm saying. The father or the mother of a child shall within 45 days after the birth of the child ensure the registration of the birth at the relevant civil registry. Instead of 45 days, you are saying 60 days. Why? No, but yes, because this one, in fact, it should be 1 week. But you are doing this because you want to regulate. You want to regulate. If you leave it open because people are going to be fined, then you are going to defeat the purpose. It means you can go for 2 months without registering your child.
You can make more sensitization.
No. After sensitization, you come back and do it and change it.
No, I mean, before the 1 month will elapse, the second month they will be able to register.
No.
45 days.
Let's look at it again. Yes, Honorable.
His agreement is that it takes some parents to a longer time to register their children. In fact, I think it's in the country, they don't even register. Now we are now trying to, some of the parents, they don't register their children. This law is now compelling them to register. So having put this
and
number...
in addition,
yes,
those who register late,
yeah,
it's compelling them to register on time.
on time. So I think
That's the purpose.
the period is actually okay.
It's 45 days.
Yeah, it's okay.
45 days, you have a child, you cannot go and get the child registered. But you can go to the market and get food and eat. You don't wait for 1 week for that. Yes.
To ask our colleague that this is actually trying to curb inaptitude. People not really wanting to go and register their child on time. There's a menace now in the society, and you're addressing that you want to relax the law again. You are just, in a nutshell, allowing it to continue. So basically, I think these measures are okay because we have to put this caveat there so that at least you put those fines so that they know that if I fail, I'm losing a bag of rice cost to pay. So they will forgo. I mean,
and and the good thing is, this is data.
Exactly. It's data.
Why do you have to wait until? I think the health is very lenient.
30 days is okay.
For me, you could.
I promote 30
the day
days.
you are going to name your child, it should be registered. It should have been registered.
Chair, I promote 30 days.
Yes, honorable member for Talinding.
Chair,
You are okay.
Yes.
just let them leave it as
Sammy.
it is.
I am talking to
Yes.
Talinding.
Yes.
45 days.
Now that he agreed.
Honorable, listen, the floor is not with you, it's with somebody. No, let me hear him. Let me hear him, and then when he says he's withdrawn, we can also withdraw. Yes,
He almost withdrew. So, but then, yes, there's no reason why we should increase it from 45 to 60. In fact, even 45 is too much, like you said. You understand? 45 is too much because it concerns data collection. And if you can budget for a naming ceremony, 1 month, Islam gives you 1 month for naming ceremony, like 1 week. From the day he's born, 1 week for naming ceremony. You can gather funds to do thousands on the naming ceremony, but you cannot pay fair to go and register.
So I think 45 is high.
No, I withdrew for number 1. But for number 1, yes. No, I mean we leave it as it is, 45 days. No, I'm not in for that.
No, 5,000 should be okay.
No. Yes. No. Chair.
Chair,
Chair.
I'm proposing 5,000.
Chair, remember, some people, they find it very difficult to pay $2,000. No.
Chair, I think I propose 5,000.
2,000. Remember, 2,000 is there. People are complaining. You are saying 5,000.
Yeah, the fine is on the low side. Chairman, Chair, I think the fine is on the low side. I'm proposing to increase the fine.
2,000 is fine. 2,000 is okay.
$2,000 is okay. Are you okay with 2,000?
Now your proposal is 500. There is another proposal of 5,000. You alone. You alone.
No, no, no. Let's vote, but I will not withdraw.
26. Oh, it's 26. 26. 26 2. Where is 26 itself? 26 is here. 26 2. He said it should read, a person who does not comply with subsection 1 shall pay a registration fee as prescribed in a regulation. Honorable, we will not give that to them to make a regulation. No. This one, we are going to make it, we are going to determine it ourselves.
That's not safe. They can pay more than, as he said.
If you make it a regulation, it can change all the time, without you even knowing.
No, but if the compliance of registration is really very high, there could be some additional reasons why somebody did not do that. We encourage everybody to register.
2,000. 2,000.
No, but yeah, you see, they can even put 2,000, but along the lines, if they feel that they can make it 3 or 4 or 5, they can do that. So you don't want to make it so static in the act. So you make no wait. Hey,
let him learn.
Vice Chair, Vice Chair, excuse me, Vice Chair.
Okay.
Now, please don't. Honorable Chair, tell him to withdraw that.
Chair,
I'm not the vice chair of the committee.
Chair, can I help him? Can I come in, please?
No, honorable member for Upper Salum is on the floor.
Yes, Vice Chair, I withdraw. No Vice Chair. Okay.
Yeah.
So, Chair, what I'm trying to say is, I'm not opposed to 2,000. In fact, even if you make it 5,000, I'm fine. What I'm just saying is we put it in a regulation so that if there's a need for them to increase whatever, they can go ahead and do that without actually coming to change the act.
Yeah, you know, we also don't want people to abuse it.
But I trust
You
them.
may have a very good somebody who is there. Tomorrow
Yes.
you may have somebody else.
Yes. But I trust them. They do the right thing.
No. You know,
No, I trust them. I trust them.
Yeah, you are held here by the people. So you are going to be more careful.
No problem, Chair. I think we can leave it like that. But I know most of the members, they will pay for it. Go ahead. You'll be one paying.
Chair.
Somebody,
Chair.
yes?
Yes. Thank you very much.
I have these ones with me. When I'm ready, I call you. Where is the other one? Upper Saloon. Sam, we have finished them. Okay. Hey.
No debate.
We are on 26, huh? Hey. 26, the question. I think somebody.
Honorable members, it is proposed that clause 26, duty of parents, stands part of the bill.
Yeah, that's where we are.
Wait, put off your mic. Put off your mic. There is a proposal from the member for Woolly East on clause 26 sub 3 and a parent or guardian.
Yeah.
Don't put on your mic like that. You cannot speak. No, wait, I'll come to you. There is a proposal from the member for Woolly East, 26.3. A parent or guardian shall sign the register. 26.3. Let's look. A parent signs the register of births when the birth of his or her child is registered. So everyone want to say a parent or guardian shall sign the register. The member for Woolly East, I think it is.
I'm saying you have scenarios where the mother passed away and then the father is outside. So you have to concentrate on the guardian. Yeah.
Or guardians shall sign the register of births when the birth of his or her child is registered. You know, after parents, you add or guardian, shall, and you add or guardian shall sign the register. Continuation. Yes, Woolly is? Yes, that's what he said, shall sign. Yes. 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 Woolly, Nyamina West, sorry, Same, my neighbor.
Thank you very much, Chair. We are at 26.2. We are at 26.2. We are at.
There is a proposal from the member for Same on 26 sub 1.
No, what? I have
Okay,
withdrawn that
26
now.
two.
Two.
Or 2.
Yes.
His withdrawal, a person who does not comply with subsection 1 shall pay a registration fee of from 2000.
Date of 2000. That was my submission. So now let's just try and come to a consensus about it. Either people agree or not.
Please, that has been debated extensively, and then we have advised to withdraw if you don't.
That's the procedure. I said I will not withdraw. No, let's vote. Or we discuss about it.
Honorable members, there is a proposal from the member for Same from 2,000 to 500. Are you in support of it or no? That's why I'm not allowing any debate on it. I'm not allowing any debate.
Let's vote.
Those in favor of, put off your mic. Those in favor of the proposal from the member for Same to reduce it from 2,000 to 500, say aye. Those not in favor, please say no. The noes have it. It is proposed that clause 6, duty of parents, 26, duty of parent as amended, remember the guardian shall stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Yeah.
Clause 27, alteration of name of a child.
Clause 27, alteration of name of a child. It is proposed that clause 27, alteration of name of a child.
Chair.
Yes?
Yes, in clause 27, alteration of name of a child. You know, here it is saying that A parent or guardian of a child may change the name whose birth is registered in application writing registers. The payment of prescribed fee. This is where I wanted to come in.
Where?
The prescribed fee here. This is that this will be at the
Regulation.
This will be a regulation.
Yes.
We are arguing here before that in this case, should it be necessary? I think it should be necessary for us to put the fee here.
No, because in this kind of thing, you don't put the fee and in the bill. We do in the registration, in the regulation, because time to time it's subject to changes. No, it's not the same. It's not the same. It's not the same. This is a prescribed fee. This is a regulation. Honorable members know. It is proposed that clause 27, alteration of name of a child, stands part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. We will not
Clause 28,
members were
prohibition of nameless
Ministry of
birth
Health
registration.
We will not waste time here. It is proposed that clause 28, prohibition of nameless birth registration.
I want to ask the minister a question here.
Yes, go ahead. Honorable Chair.
Yes.
Any other member who have something to add to this, you go straight to the point.
Thank
because
you.
over the weekend, you debated extensively on the bill. I will not allow any debate on this. No. Nyanija, yes, go ahead.
Okay, thank you very much. You know, here it is said prohibition of nameless birth registration. For instance, before a child is given a name, how do you do this registration? When you want to do registration, before a child is given a name.
No, you cannot drag us here. No, we will not do that. Yes, Minister.
No, I don't expect the chairman to be saying that.
You cannot do that.
Yeah. So these people, they want to tell me to take the president of our plenary.
No, you cannot use a mic without the leave of the chair. You cannot do that. Minister.
Thank you very much. Fortunately, a lot of the births now are in health facilities.
Yes.
Gambia has achieved 97% hospital-based or facility-based delivery now. So when they are born, all the other details are entered, and then the child is usually from the community. So after the naming, they come to put the name in the system. Yeah.
In fact, one of your staff, you need to help me, huh? It is proposed that clause 28, prohibition of nameless birth registration, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, let's
Clause
proceed.
29, registration of births outside the Gambia.
Clause 29, registration of birth outside the Gambia. You have a proposal? Okay, go ahead.
Okay. Now on 29.
I want to ask members of parliament.
Huh?
I want to ask questions to members. You were at the retreat, right? Why you people didn't ask those questions there? No, you cannot be asking this question here.
I don't care.
No.
I don't care.
No. No, you cannot.
I don't care. I have answered to your question.
No, order, please, order.
Yeah.
Let me make my point first.
Yes.
Pakala, I'll come to you. Honorable members, no, you met over the weekend, and that meeting was more or less informal committee of the whole house. You ask questions. If you have any proposal, you should write it. You should have written it since that day. Today it was just a summary of proposal. And those questions that you cannot be asking question here again. No, Serekuna, you cannot say that.
Yes. After the program, you went home, you sleep, and your mind touches a lot of other things. That's why we're asking questions.
No, your mind should have touched something before you go there that day.
At that time, you cannot.
No, you cannot do that.
Now, Honorable
That is a
Minister,
excuse.
Honorable Minister, the question I have on the registration of birth outside the Gambia. What happened, for example, somebody sends a birth certificate from somewhere outside the Gambia, said, I want this child to be registered. Do you only stop at the birth certificate, or do you go another step to ensure that that document is certified, notarized, or some other authentication, or you just register like that?
Documentation, yes. So, in consultation with my team, I'm being informed that a certified copy of that birth certificate and the parents' documentation suffices.
Thank you. Thank you. And that's the reason why I think we may need to amend 29(1)A where we call it a certificate box, something along those lines. That's why I was asking that question.
No, a certificate of birth issued by the appropriate authority in the country where the child is born. That's yeah, but that's correct. It is proposed that clause 29, registration of births outside the Gambia, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 30. Clause 30, registration of births or deaths in territorial waters.
You cannot stop NAMs from murmuring. No, they can murmur, but not to distract all. Clause 30, registration of births or deaths in territorial waters. It is proposed that clause 30, registration of births or deaths in territorial waters, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 31, registration of births of displaced persons and refugees.
It is proposed that clause 31, registration of births of displaced persons and refugees, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Clause 32, registration, certificate of registration of birth.
Clause 32, certificate of registration of birth. It is proposed that clause 32, certificate of registration of birth, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Let's proceed.
33, chief register of registrable events may request persons to register births.
Clause 33, chief registrar of registrable events may request person to register births, stands part of the bill for the proposal. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, let's proceed.
Clause 34, registration of death.
Clause 34, registration of death. It is proposed that clause 34, registration of death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 35, registration of fetal death.
Clause 35, registration of fetal death. It is proposed that clause 35, registration of fetal death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 36, burial register.
Clause 36, burial register. It is proposed that clause 36, burial register, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 37, persons responsible for giving notice of death.
Clause 37, persons responsible for giving notice of death. Quickly, Upper Salum, you have a question. Go straight to the question.
There are situations when a person is actually legally declared dead, which means a person actually has not been heard of by the closest family members, nobody, for a certain number of years, where you can, legally confirm. How do we align that here, legally? Because somebody have not heard from them for a period of a certain number of years by immediate family members. Nobody knows anything about them. Where legally they can be confirmed as he's dead, but how do we do those registrations?
Thank you very much. I remember.
No, you are talking about registration of death. This is burial. We are not there.
No, what he's saying, like for instance, you are now missing for a quite number of years. Nobody knows about like this backway issue.
Or giving person responsible for giving notice of death. Okay.
Actually, when there is no evidence that someone has died, then probably the person has not died.
Yes.
So that person is a missing person.
Yeah.
It's missed.
It's
missing. Because sometimes we've all seen, and really after 20, 30 years, some of them reappear.
Yes.
But for us to certify someone dead, that means there is evidence that people saw and certified that the person was dead. Then they can be, yeah.
It is proposed that clause 37, persons responsible for giving notice of death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, let's proceed.
Clause 38, certificate of registration of death.
Clause 38, certificate of registration of death. It is proposed that clause 38, certificate of registration of death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 39, medical certificate of cause of death.
Clause 39, medical certificate of cause of death. It is proposed that clause 39, medical certificate of cause of death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 40, when certificate is issued by a coroner.
It is proposed that clause 40, when certificate is issued by a coroner, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 41, registration of deaths occurring outside the Gambia.
Clause 41, registration of deaths occurring outside the Gambia. It is proposed that clause 41, registration of deaths occurring outside the Gambia, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, we may proceed.
Clause 42, mass burials.
Clause 42, mass burial. It is proposed that clause 42, mass burial, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 43, duty of the state to notify death.
Clause 43, duty of the state to notify death. It is proposed that clause 43, duty of the state to notify death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 44, state to bury a rejected corpse.
Clause 44, state to bury a rejected corpse. It is proposed that clause 44, state to bury a rejected corpse, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 45, registration after more than 12 months from death.
Clause 45, registration after more than 12 months from death, stands part of the bill. It is proposed that clause 45, registration after more than 12 months from death, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Clause 46, chief register of registrable events to issue certificate of burial.
Clause 46, chief registrar of registrable events to issue certificate of burial. It is proposed that clause 46, chief registrar of registrable events to issue certificate of burial, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk,
Clause 47, burial of deceased child as fetal death.
Clause 47, we have a proposal from the member for Woolly East proposing on 47 sub 1. And he said it should be reformed because it is not clear. This is a proposal. No.
Chair.
No.
No, wait.
No, this is a proposal. No.
What do you mean?
No, you didn't put any proposal.
Listen to me. This is not clear. It's
I'm
saying.
not going to listen
Can
to
you read it?
No, if you want clarification from the minister, you should sort clarification. But it's a proposal.
But that's what we are doing. This is a
you are not-
clarification.
no, just ask a clarification. But
Are you a judge today?
Huh?
You are acting like a magistrate.
I didn't hear you say.
Are you a magistrate?
No, I'm not only a
You are
magistrate.
too
but I'm a
legal
judge.
today. Well, we
No,
just
I'm not-
listen
no,
to the
I am
sentence.
I'm not a magistrate.
Okay, I want a clarification
I am a
from the
judge.
minister.
I'm performing the function
Chair.
of a judge.
Chair, I want clarification from the minister.
Minister, please.
A person shall not bury or dispose of the body of a deceased child as if it were fetal death. It's giving an impression that if it is fetal death, you can go ahead and bury.
Actually, this is a very important clause. This tries to control infanticide. When a child is born and the pregnancy, for example, was not wanted for any reason, and then probably even the child would have been murdered. What we call infanticide, and now it is reported that the child was born dead. Because, you see, if it were a different individual who was alive, interacting with people, everybody would have known the existence of that individual, that other child that has been there. But this one, for example, is born just an hour ago, and then you get a report that actually the child came out lifeless. This is what it is controlling. This is the statement. And it is controlled.
Maybe you need to explain that.
Yeah.
Fetus, maybe I'm alone.
No, but he's saying fetal death. If it's a fetal death, of course, that means the child came out dead. But what it's trying to say is, if a child came out alive, that child should not be buried as if it came out dead. But the idea is to control, but the idea it is also whatever situation the child comes out in, there has to be verification if a person dies. The notification process, even if the child was born in the community, which we are discouraging, but you see that notification of death in the community, there is a clause for that, if it happened in the community and not in a hospital.
Will you use your mic?
If a child, if there is fatal death, if there is fatal death, should the parents notify the chief register in any way?
So there is.
This is giving an impression that if it is fatal death, you don't need to do that. At least if it is not fatal death.
Yes, there should be notification. If there is fetal death, there should be notification.
Yeah, so why
I think you are trying to, if I got it right, you are trying to say irrespective. That this clause might not be relevant because even if there is fetal death, there should be notification. Is that the argument? Yes, that makes sense. Let me consult quickly, or maybe I can be analyzing.
What?
Yes.
What? No, honorable member fully is. You should read the clause.
Shall not bury or dispose of the body of a deceased child as if it were fatal death.
Yes.
So I am saying, if it is fatal death, should you still not notify? Because this is giving the impression that if it is fatal death, you don't need to.
It is somewhere
notify.
else.
You don't need to notify.
Yes, Opasalo.
I don't think it's necessary because if you look at the definition of fetal death, it has given a definition. Means death of a product of conception, irrespective of the duration of the pregnancy. I don't think need to report those ones.
We don't need to belabor on this. It is proposed that clause 47, burial of deceased child as fetal death stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 48, registration of civil marriages.
Clause 48, registration of civil marriages. It is proposed that clause 48, registration of civil marriages, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 49, registration of Muslim marriage and divorce.
Clause 49, registration of Muslim marriage and divorce. We have a proposal from the member for Wulde East that's proposing 49 sub 3 to read to add or district tribunal. You know 49.3, yes, I'll come to you. 49.3, a Muslim divorce shall be registered by the registrar at the various Qadi courts with the approval of the presiding magistrate, presiding Qadi.
Question is whether district tribunal is the same as Qadi.
No. No, you cannot put this district tribunal. You cannot put district tribunal there because marriages and these things and divorces, as they relate to them, it's. He wants us to add. He wants us to include district tribunal. Minister, he wants us to include district tribunal. No. To 49 sub 3.
49 sub 3. Divorce shall be registered by the.
I don't think it's applicable here.
By the various Qadi courts, approval of the presiding Qadi. Yeah. But we'll consult with Minister of Justice.
Huh?
But where's
Yeah. Member for
You have Kadi courts only in administrative places, administrative original capitals.
Minority Leader and Member of Brikama, you have the floor.
Yeah, I want the minister to clarify. Earlier on 48, we have registration of civil marriages. We doesn't take and divorce, where in the case of 49, registration of Muslim marriage and divorce. If you go further, 52, registration of Christian marriage. Why is it that only for the Muslim marriage we have and divorce, but the others we don't have divorce?
Which one?
What?
They were separate.
No, we have not gotten there. 53.
48. It's registration of civil marriages. I'm asking why we don't have divorce under civil marriages.
No, when you go to 53, it's there.
50?
Yeah, it's at 53, Minister, honorable member.
Okay.
It is proposed that clause 49, registration of Muslim marriage and divorce, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 50, notification of Muslim marriages and divorces.
Clause 50, notification of Muslim marriages and divorces. It is proposed that clause 50, notification of Muslim marriages and divorces, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 51, Muslim marriages and divorces taking place within the Gambia.
Clause 51, Muslim marriages and divorces taking place within the Gambia. It is proposed that clause 51, Muslim marriages and divorces taking place in the Gambia, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 52, registration of Christian marriage.
Clause 52, registration of Christian marriages. It is proposed that clause 52, registration of Christian marriages, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 53.
Clause 53.
At the workshop, there was concern regarding customary marriage registration. So I don't know what the minister concluded in that concern that was expressed by members, that there's a need to register customary marriage.
What is customary marriages? Those who are not neither Muslim nor Christian. Customary. Whether it's referring to customary marriages that are neither Christian nor Muslims? Because if they are Christian or Muslim, they are captured.
Yeah. The Minister of Justice people are not here. I've not seen them. But of course, we all know the challenges with regards to the customary marriages. I was thinking probably that could be inserted subsequently if we get to know the details and we standardize them, because sometimes really it's a challenge. But that could become in another piece of legislation. That's what I'm thinking.
It's not.
Clause 53, registration of divorce or annulment.
It is proposed that clause 53, registration of divorce or annulment, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Now, Salom, yes.
On the registration of divorce of annulment, I want to bring this back again. If you look at the Matrimonial Causes Act, which is an act of parliament, under section 15 is telling the presumption of death and dissolution of marriage. That is the presumption I was talking about, legal presumption that somebody is dead because of a period of time. Now, if somebody goes to file using the Matrimonial Causes Act that I'm asking for divorce because of my husband or my wife after a certain number of years, as enshrined in the law, that person is dead because it's presumed dead legally. Now, that same person cannot be registered that this person is dead. Now, how do you reconcile those two? You are divorcing because of it's presumed that the husband is dead or the wife is dead. But in actual fact, if you go to the other side where the registration of annulment also is there, wouldn't we have some issue there?
No, usually they divorce because after some period of time, you cannot hear from your husband, no communication.
Yes.
You are not divorcing based on presumption of.
No, that's exactly what the law says. Presumption. It's a presumption of death and dissolution of marriage. That's what the law says.
No, you said divorce. If you want to divorce.
Yes.
If you want
Because
to divorce.
you can use that as a reason to divorce. That's what the law is saying in the Matrimonial Causes Act.
Yeah, but in most of instances, the reason, in fact, all the cases, the reason that they use is that I have sat for a number of years and then I'm divorced because I can't hear from my husband.
Yes, and the reason for divorce is the person is presumed dead.
No, the reason for divorce would be I have not heard from him for a number of years.
No, that cannot be a reason based on the law.
My contribution to that, honourable member, is the qualifier, presumption. So that's the qualifier. It's presuming. There's no evidence of that.
That is correct.
But so it's assuming that based on that length of period, this person can be considered to be dead, and in even the interpretation, the literally meaning, and then looking at the circumstances. If someone is not there for that number of years, probably is probably thought to be as good as dead in the marriage. So
yes.
That's why it's presumption. But when it comes to the civil registration aspect, there has to be evidence of that. That is why even if, fortunately, quite a lot of people understand now. Even if a person dies at home, they carry the body to EFSTH for certification of death. Because it has happened in the past, probably not here, that people see people at home and they think they have died and they are actually living. So that's why there has to be medical evidence of death. Now, if it happens at home for regularization and they happen to bury before that, so to certify that, they have to do a verbal autopsy, get the details, fill in the forms, talk to the community leaders, and so on and so forth. In that case, they can now issue the death certificate. So that's the rigor that they go through. Yeah.
Yeah.
The member for.
What I was just trying to clarify, you know, you already also have a registration of death. So which means this person that is presumed for the marriage issue will not be registered under the registration of death because it's already presumed. Because this one, you need to have physical evidence that this person is gone. Thank you. That's all I needed to get clear.
Member for Brikama, a minority leader.
That is clause 53(4), where a Muslim divorce is not issued by the court. The parties to the divorce shall ensure the registration of their divorce with the principal registrar of the Kari court. Which court is this one referring to? And then also whether the first court, issued by the court. Yeah, whether the district tribunal, because some of the divorce at the local level are taking place at the district tribunal. So whether that will not be considered.
Because what they are saying here, where a Muslim divorce is not issued by the court, it can be any court.
That's what I want him to clarify. Which court are they referring to? And whether district tribunals should not be considered. Why they should not be considered?
Read it again. It's where Muslim divorce is not issued by the court. The parties to the divorce shall ensure the registration of the divorce with the principal registrar of the Kadi court. Well, the Minister of Justice are not here now, but the representative. But I'm assuming this is the normal court. They say where it is not.
No, Honourable Minister.
Yeah.
Honourable Minister. No, you know this one. It says where a Muslim divorce is not issued by the court. The parties to the divorce shall ensure the registration of the divorce with the principal registrar of the Kadi court. Now, when you look, you know, constitutionally,
yes,
marriages and divorce as they relate to Muslims, is for the Qadi court. So maybe here the court is referring to the court of the Qadi court.
Presumably.
So if it is not, if it is not issued by the Qadi court, then you go to the principal registrar of the court, of the Qadi court. I'm not assuming, it's a constitutional provision.
Is it?
It's a constitutional provision.
The court is referring to Qadi court.
Yes, because it's a constitutional provision. Muslims and marriages and divorce are had by the Qadi court. It's a constitutional provision. So
And
now
Qadi
here is saying, in the event that the court have not issued the divorce, you can go to the registrar.
Linked to, Honorable, it's linked
Yeah.
okay.
If you look at the interpretation, even for court, it's there. You are not assuming, you are very right. Court means the High Court for dissolution of civil and Christian marriages. And it says, when further to say B, also it means Qadi Court for Muslim marriages. So you are not guessing.
It means Qadi court for Muslim.
And if you go, Honorable, let me just clarify this. Let me get to this. If you start from the top, 53.1 and 53.2, then you go to 53.3.
And then you know what they are also telling.
Yes. No, I was just saying, if we read the whole thing, clause 53.1 and 2 talk about the High Court for the civil marriage. You see, where a divorce or an annulment of marriage is granted by the High Court, the registrar of the High Court shall register the divorce in the civil registration system. 2, the certificate of divorce in the High Court is set out in Schedule 6, Part 5. 3, where divorce is granted by the Qadi Court, the principal registrar of the Qadi Court shall register the divorce in the civil registration system. Now, 4 now saying where a Muslim divorce is not issued by the court. So that's the Qadi Court.
But again, I raised that
Yes.
Certain Muslim marriages are settled at district tribunals.
Yes.
The divorce are settled at district tribunals. Yeah? Certain Muslim marriages, the divorce are settled at district tribunal and it's binding. Why is that not considered in this case?
Oh, Minister, Honorable Minister, your mic. You know, order here. Listen, order here. You know, when you divorce your wife, if your wife divorces you at home, you know, it is not through the Qadi court, but you are Muslims. And then it is not issued by the court, but you can choose to go to the principal registrar to register the divorce. You are obliged. Yeah, you may do that. Not issued by the court, but you can go to the registrar and register. Yes, you are obliged. Yes, Opasalum.
What I wanted I want to align myself with the minority. Let's look at the laws that are administered by district tribunal. If you look at the District Tribunal Act, it's telling you that the laws to be administered include the Sharia law related to civil status, marriage, succession, divorce, dowry, etc., etc. Now, in the way we define court here, it actually excludes district tribunal. And the district tribunal actually, they settle divorce, marriage, a lot of other things.
No, you know, at the district tribunal level, they only probably based on traditionally bringing them together also, but they cannot. But constitutionally, but constitutionally is the Qadi court. No, honorable members, you know, they can settle or they have been settling. But this piece of legislation, they are not empowering or recognizing the district tribunal. Yes.
So, actually, let me make it simple, if I may. It's actually talking about the registration, not who dissolves the marriage.
Exactly.
So now, you see, 3 Where the divorce is granted by the Qadi court, the principal registrar of the Qadi court shall register. So the emphasis on the registration, the divorce in the civil registration form. But now, where it is not done by a court, the district tribunal is one of those. If they decide to do it on their own at home.
Or at home.
But the mandate is they are mandated to register it.
Okay,
So that's the idea.
Minister,
Yes.
let me just.
It is proposed that
Chairman, why don't you put Kadi or the district tribunal?
No, they are not bringing in district tribunal to the appeal. Don't put district tribunal in the appeal, my friend.
No. Chairman, wait, just wait. Where a divorce is granted by a Kadi court, or a district tribunal. No, don't they, majority leader, they are not bringing district tribunal into the appeal. Put it there. They are not putting district tribunal in the appeal.
In that case,
Attorney General bring this. They are not bringing that. No, don't do that. Honorable members, you have to be fair to the minister. Don't bring district tribunal to his bill. Don't do that.
Honorable Chair, we are not bringing district tribunal. Just excuse me.
No, Chair. Honorable members, you see, the Constitution vested in terms of marriages, divorce, inheritance to the Qadi courts for Muslims. And for the district tribunals, it's the customary tribunal. It is not. You are mixing the two. And the Constitution, no, honorable members, no.
They have both civil and criminal. They have both civil and criminal.
No, you cannot use your mic. You cannot use your mic like that. No, but it's customary. They of course, it's a customary. They sit in the Bantaba and decide and call some elders. Let's vote.
Planning is that now that I know the court means Qadi court, so any divorce that is not done in the Qadi court, being district tribunal or what, should go and register at Qadi court. That's what it means. It's clear.
It's very clear. That's what he's saying. It is very clear. It is proposed that clause 53, registration of divorce or annulment stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. Ayes have it.
Clause 54, marriage form.
Clause 54, marriage form. It is proposed that clause 54, marriage form, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. Ayes have it.
Clause 55, publication of intention to marry.
Clause 55, publication of intention to marry. It is proposed that clause 55, publication of intention to marry, to stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 56, issuance of certificate by Registrar General.
Clause 56, issuance of certificate by Registrar General. It is proposed that clause 56, issuance of certificate by Registrar General, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 57, marriage to take place within 3 months after date of notice.
Clause 57, marriage to take place within 3 months after date of notice, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 58, proof of age.
It is proposed that clause 58, proof of age, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 59, caveat.
Clause 59, caveat. It is proposed that clause 59, caveat, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 60, caveat referral to the High Court.
Clause 60, caveat referral to the High Court. It is proposed that clause 60, caveat referral to the High Court, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 61, removal of caveat.
Clause 61, removal of caveat. We have proposal from Woolly East 61 sub 1B. The word cancellation should be replaced with the word cancel in line 2. In line 2 of 61. 61B. In line 2, cancellation. Write the marriage notice book immediately before the entry and cancellation the word. And cancel the word cancel. It is proposed that clause 61, removal of caveat, stands part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, let's proceed.
Clause 62, cost.
Clause 62, cost. It is proposed that clause 62, cost, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Chairman, sorry for taking you back. I didn't get what you said with regards to 61.
Cancellation of the cancel. Cancellation should be cancelled.
Yes. Well, the reading goes like this, if I may. Write in the marriage notice book immediately below the entry and the cancellation words. So this is what this is what we are going to write beneath the marriage registry. Write in the marriage notice book immediately below the entry and cancellation. For example, cancellation the words. So this is the words cancelled.
No, you put off there. Cancellation of the word.
Right in the marriage notice.
It's either be cancel the word or cancellation of the word.
Okay. Okay, I'll analyze it again, if I may. We can go. Yes. Okay.
Minister, are you okay?
Yes, I think it's fine.
You're okay? It's fine.
Okay.
Clark? No, he said it's okay as it is. As we did, he said it's fine. Clark, let's proceed. It is proposed that clause 62, cost, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 63, marriage in Register General's office.
Clause 63, marriage in Register General's office. It is proposed that clause 63, marriage in Register General's office, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 64, married when invalid.
Clause 64, marriage when invalid. It is proposed that clause 64, marriage when invalid, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause, it says 66.
What is this?
Sub-clause. Okay. Dan, remember, from one clause then transfer. Clause
64. It's not 66.
No.
Okay. 66.
Yes.
Clark?
Yes, let me just put it.
Clark, name clause 66.
Clause 66. Clause 66. Correction of errors in the civil marriage register.
Yes, clause
Yes.
66. Member
Yeah.
Kunyanija?
Yes, the committee have something, the consultation with the ministry. The heading, first of all, should be amended to read as correction of errors in the civil marriage register and cancellation. Cancellation should be added there. Then what we moved earlier from clause 18, sub 6 and 7 will be replaced here as subclauses 3 and 4, and then subclause 3 as it is right now, subclause it was rather in subclause 6 will be amended further, where you have chief registrar to be amended to read as registrar general.
Where? Oh, 18.
You understand?
So now what are you inserting here?
Wait, please. What we are doing right now, we moved subclause 6 and 7 as it was in 18
and
place it here as subclause 3 and 4.
Oh, is that what you agreed on the members?
Yes. And further amend subclause, the new subclause 3 to change chief registrar to read as registrar general.
It is written, get it to the table clerk. It is proposed that the same.
Chair, no.
Yes, member for Kiang West. I don't know where are you.
Addition of amendment. I went on, let me put that on record. If you don't know where I was, I went on official mission.
Additional amendment.
Addition of cancellation on the heading. If you look at the head, it says correction of errors in the civil marriage register. Correction of errors includes cancellation. So even if you add cancellation there or not, it's also part of correction of errors.
But is it bad to add cancellation?
But it doesn't cause any harm. How it is right now, it doesn't cause any harm because both cancellation is part of correction of errors.
No, errors and cancellation is not the same.
Yeah. Honorable.
No, it's not the same.
Cancellation of...
No, it's not the same. And you are getting all those clauses, you are lifting them from 18 and 20. They are not the same.
When you cancel, you are still correcting an error.
No.
Of course.
It is proposed
Honorable,
clause 66.
what is the difference?
Correction of errors in civil
Honorable Chair.
Registration
Chair.
and cancellation
Honorable Chair.
part of the bill
Chair.
as amended. Those in
Chair.
favor, please say aye.
Chair.
Those not
Chair.
in favor, please say no.
Chair.
The ayes have it.
Chair.
Clause
Yes,
67,
Chair.
unlawful
Chair.
celebration of marriage.
Chair.
Clause 67. Yes, sir.
Chair.
On 67.
Honorable Chair. Chair. Daniel, they cannot off my mic. I may have right to talk here. He has to listen to me. If I don't understand something, I'm seeking clarification. You have to do that. To what point do you think cancellation of errors, correction of errors and cancellation is different? They have no clarification
Honorable
on that.
members.
How
Honorable
do they think
members.
that is different?
Clause 67. Unlawful
Honorable Chair.
celebration of
Honorable
marriage.
Chair. Honorable Chair. You are not fair.
Thank you very much. Okay. Thank you very much. Okay, sir. Okay, sir. You are fair. Okay, sir. Thank you very much, sir. You are fair, sir. You are fair, sir. 67. Go ahead. It is proposed that clause 67, unlawful celebration of marriages.
Point of order.
The bill.
Point of order.
Please say aye.
Point of order.
Those not in favor, please say no. The ayes have it. Clerk, let's proceed.
Clause 68, false declaration.
Clause 58, false declaration. It is proposed that clause 68, false declaration, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 69, addition of religious ceremony to civil marriage.
Honorable member for Kiang West, please don't do that again. Don't come here again and disrupt. Honorable member for Kiang West, Sergeant at Arm. Sergeant at Arm, can you remove him away from this place? Sergeant at Arm, take him away from this place. Move him away from this place. Yeah, of course. Remove him away. Sergeant at Arms, take him out of this place. Sergeant at Arms, take him out of that place. Sergeant at Arms, take him out of that place. Let him move out. Sergeant at Arms, take him out of this chamber. Honorable member, who I sent to fucking leave you? Honorable member, let him leave the chamber. Sergeant at Arms, let him leave the chamber. Sergeant at Arms, let him leave. Sergeant at Arms, let him leave this. Okay, Sergeant at Arms. Sergeant at Arms. Order, order, Sergeant at Arms. Sergeant at Arms. Sergeant at Arms. Allow the member for Serekunda West to talk to him. Sergeant at Arms, allow the member for Serekunda West to talk to him. Allow the Serekunda West to talk to him. Yes. But for Serekunda West, talk to him to leave the chamber. No, honorable member for Woolly is, there is no will for calm down. No, if you want to leave, you can leave. No, you will leave. Honorable members, order.
Remember, we are in Ramadan, please. We are in Ramadan. Camera, we are in Ramadan, please. Open your me. No. Honorable members, order. Lower Salum. Lower Salum, wait. Yeah, the member for Woolly is order. Honorable members. The member for Woolly is. Those were not nice comments, and they should not come from an elderly person from you. Those were order, honorable members, order. Those comments were not expected of a senior member. No, honorable members. No. If you want to leave, you can leave. Honorable member. Honorable member. Honorable members. Honorable.
Chair, point of order.
Honorable members, order, order. Clerk, let's proceed.
Clause 68, false declaration.
Clause 68, false declaration. Yes, the member for Woolly East, there is a proposal from Woolly East. And it reads, Clause 68, the phrase, and I quote, if he or she makes the declaration knowing that the matter is false, should be deleted because it's already captured at the top. 68. False declaration.
Who swears to or fails to take reasonable means to ascertain the truth or falsity of a material matter in any affidavit required by law to be made for the purposes of inquiries antecedent to issuing a certificate under this part, commits an offense and is liable to, a fine not exceeding 50,000 for a term or a term of imprisonment not exceeding 1 year. Full stop.
Honorable members, are you following? You see, on the B, last, commits an offense. He said, if you read it to the second line, where not exceeding 1 year, it should end there. That's what he's proposing. Because, to continue, if he or she makes the declaration knowing that the matter is false, it's captured because it's under false declaration. Yes, Oposalum?
Yes, I think what he's saying makes a lot of sense. But I just want to also ask a question along the same lines. If the person doing the registration also knows that what this person brought is also false, what happened? Okay.
And also, on the B, you see fails raw. It should be fails to. Fails all or RO. It should be fails to. TO. It should be T, yes. It should be fails to take responsibility. Reasonable means, It is proposed that clause 68, false declaration, stands part of the bill. Those in favor, please say aye. As amended, with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 69, addition of religious ceremony to civil marriage.
Clause 69, addition of religious ceremony to civil marriage. It is proposed that clause 69, addition of religious ceremony to civil marriage, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 70, fees.
Clause 70, fees. It is proposed that clause 70, fees, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 71, the Judicial Service Commission to appoint registers of Muslim marriages and divorces.
Clause 70. Clause 71, the judicial... Yes. We are now going to 71. He's in Salud. Clause 71, the Judicial Service Commission to appoint registrars of Muslim marriages and divorces. It is proposed that clause 71, the Judicial Service Commission to appoint registrars of Muslim marriages and divorces, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 72, functions of the Register of the
Honorable
Qadi Court.
members, clause 72, functions of the Registrar of the Qadi Court. I have a proposal from the member for Woolly East, and under 72D it reads, he said add the word be after the word may. Let's go to D. D. He said add the word be after the word may. Keep books in any form as may be prescribed. As may be. It is proposed that clause 72, functions of the registrar of the Cadi Court as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 73, marriages and divorces to be registered.
Clause 73, marriages and divorces to be registered. It is proposed that clause 73, marriages and divorces to be registered, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 74, registrars of Cadi Court to make enquiry.
Yes. Yes, member for Kiang West.
No, I'm not seeking for the floor. Neither. I have spoken to my deputy minority leader with respect to the altercation. So probably that's the reason why he requested for the floor. He advised that I withdraw the words that I have uttered. By respect to the parliament and to the procedures, I humbly withdraw.
Thank you, Honorable Member for Serekunda West. Thank you. I have high regard for you. He has been a childhood friend to your daughter, and based on the basis of your elderly and that wisdom, I accepted to allow that to happen. Thank you very much, sir.
Clause 76, in issuing certificate to parties.
76 or 74? 74.
74. 74, registers of Cadi Courts to make inquiry.
Clause 74, registrar of Cadi Court to make inquiry. It is proposed that clause 74, registrars of Cadi Court to make inquiry, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 75, entry of marriage or divorce.
Clause 75, entry of marriage or divorce. It is proposed that clause 75, entry of marriage or divorce, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 76, issuing certificate to parties.
Honorable members, clause 76, issuing certificate to parties. I have a proposal from the member for Woolly East on 76 sub 1 and sub 2. And what is saying, the word appeal should be pluralized. The appeal should be pluralized.
The court is appeals court, Cadi appeals court, isn't it?
No, it should be Cadi appeal court.
Yes, it's Cadi appeals court.
Appeals.
Yes.
It should, you know, the Cadi, it should be the appeal panel. I'm not sure. The Cadi appeal panel. And I don't think it should be appeals. You know, every appeal is an appeal of its own. So you are not boxing all the appeals together to say appeals court. I think it should be appeal court. They deal with appeal. Every appeal comes, they deal with. I think it should be appeal court, not appeals. Huh? Yeah, it should be appeal panel. It's appeals. Appeals. Okay, he said Cadi appeals panel. Yeah, appeals panel, yeah. So we can still add the S then. Or we leave it as it is, because it's an appeals panel.
The Constitution?
No, the Constitution is appeal.
Yeah, it's supreme, yes.
Yes. No, he's right. He said we should add S to be appeals. So we thought it's only appeals. He's right. So do we, honorable members, it is proposed that clause 76, issuing certificate to appeals as to parties as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 77, record of refusal to register.
Clause 70.
Chair, again, the appeals there. Take note of it.
Wherever it appears.
Yes, we can.
And, yeah, okay. Clause 77. The other one, wherever it appears instead of appeal to appeals. Clause 77, record of refusal to register. Hold on. Because what they are saying is for the appeals panel, not the court, not the appeal court. No, that's what he said. He said it's the Kadi appeals panel, but not appeal court. So he said they are saying the appeals should not be appeals. It's proposed that clause 77, record of refusal to register, honorable members, Upper Salum and Lower Salum. I don't know why I always keep Pakala, yes. No, you know, honorable members, what they are telling me, you know, on 76, member for Wool East, the one 76 to Kadi, 76-1, and even to Kadi Appeal Court, it should be, what they are proposing is to read as Kadi Appeals Panel. No, we have only Kadi Appeals Panel. We don't have Kadi Appeals Court. Yeah. No, it's not established. No, it should be Appeals Panel. Yes. So maybe we can. Now what we do, we should rescind our decision on that and to move that wherever it appears as Kadi Appeals Court to be Kadi Appeals Panel. Now.
Okay.
No, Chair.
It's S. Yes. Member for Upper Salum, Lower Salum.
Yeah, no, it's me.
Kenyanija.
Yes, the fast track, because you know we are dealing with the constitutional provision. I was even finding out. But now I move that we rescind our earlier decision on 76.
Any seconder?
Yes, second that.
Okay. It has been. Yes. It has been moved and seconded that we rescind our earlier decision on 76 and also wherever it appears as Kadi Appeal Court. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. Now move wherever.
Yes, I equally move that wherever Kadi Appeal Court appear, it be replaced with Kadi Appeals Panel.
Any seconder? It has been moved and seconded that wherever the word Kadi Appeal Courts appears in the bill to be changed to Kadi Appeals Panel. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Now I will put the question on 76. Yes. Honorable Minister, please.
So in that case, do we have to indicate this in the section of the interpretations? Because we did for the courts and then the...
Everywhere it appears in the bill. For Kadi, wherever it refers in the bill, Kadi Appeals Court, it will be changed to Kadi Appeals Panel. We have just voted on that now, including the interpretation. Including the interpretation, we said anywhere in the bill.
But probably in the interpretation, there is no Kadi Appeals Court. There is Kadi Court. So if now Kadi Court will not be...
You know you have a Kadi Court.
Yes, that's
Kadi Court is correct.
Is there?
Yeah, that is correct.
So, but there is no Kadi Appeals
Court.
Court.
No, there is Kadi Appeals Panel. So wherever it appears in the bill, refer to Kadi Appeals Court.
Okay, but I'm just thinking, since it's an introduction now, Kadi Appeals Panel, is there a need for it to be under the interpretations as well? Okay.
Yeah. Yeah.
Yes, on Kalak, yes, please proceed. Yes, Upper Salum, Lower Salum. Decided. Yes.
Clause 77, record of refusal to register.
Yes. You are lost.
Yes.
Clause 77.
Yeah.
No?
I'm lost. I want to come back. And you allow me to come back.
Yeah, go ahead.
Here, the Kadi Appeal Panel is established under this constitution, of 1997 constitution. It hears appeal from the decisions of the courts, where chairperson and other members acknowledge the Sharia law to sit and form a panel. It's an existing body. You agree?
We said that's why we said we have Kadi Appeals Panel established by the Constitution. Yes, we agree with you. Thank you. It is proposed that Clause 77, record of refusal to register, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 78, appeal from refusal.
Clause 78, appeal from refusal. It is proposed that Clause 78, appeal from refusal, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 79, registers and certified copies of entries as evidence.
Clause 79, registers and certified copies of entries as evidence. It is proposed that Clause 79, registers and certified copies of entries as evidence, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 80, licensed churches.
Clause 80, licensed churches. It is proposed that Clause 80, licensed churches, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 81, conduct of marriage.
Clause 81, conduct of marriage. It is proposed that Clause 81, conduct of marriage, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 82, ministers of religion authorized to publish bans of marriage.
Clause 82. Huh? Is it
it's like
Okay. It is proposed that clause 82, ministers of religion authorized to publish bans of marriage stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 83, condition precedent to publication.
Clause 83, condition precedent to publication. It is proposed that clause 83, condition precedent to publication stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 83, condition precedent to
84.
publication. Clause 84. Clause 84, book to enter publications of bans.
Clause 84, book to enter publications of bans. It is proposed that clause 84, book to enter publications of bans stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 85, license for marriage without publication of bans.
Clause 85, licenses for marriage without publication of bans. It is proposed that clause 85, licenses for marriage without publication of bans stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 86, when a new license is necessary.
Clause 86, when a new license is necessary. It is proposed that clause 86, when a new license is necessary, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 87, conditions precedent to grant license.
Clause 87, conditions precedent to grant license. It is proposed that clause 87, conditions precedent to grant license stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 88, certain proofs not necessary.
Clause 88, certain proofs not necessary. It is proposed that clause 88, certain proofs not necessary, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 89, certain marriage declared void.
Clause 89, certain marriage declared void. It is proposed that clause 89, certain marriage declared void, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 90, where no proceedings may be taken.
Honorable members, clause 90, where no proceedings may be taken, and I am in receipt of a proposal from the member for Woolly East on 90 sub 2, and he won on court seduction should be deleted. Notwithstanding subsection 1, a person may institute legal proceeding to claim damages for breach of promise to marry. No. This clause, no. No, Billy, this clause is not, no. This clause is not appropriate. Yes, member for Lower Salum, this, no, honorable members order, this clause should be deleted completely.
Completely. Honorable Chair.
This clause should be, look at the clause. Member for Lower Salum.
Honorable Chair, I propose this clause 90 subsection 2 to be deleted completely from this act, because no, honorable.
How do you go?
No, honorable Chair. Honorable Chair. Honorable Chair. No, honorable Chair. Honorable Chair. Honorable Chair. Honorable Chair. Honorable Chair. Yes, you know, the reason why, Honorable Chair. Honorable Chair, this clause is totally, you know, bad in.
Yes, Lower Upper Salum.
No, no.
Lower Salum, please.
Honorable Chair. Honorable Chair, if you go to the 1997 Constitution, if you go to, give me the 1997 Constitution. The Constitution. No, it's correct. It's wrong.
Lower Salem, yes.
Yes, Chair.
It is Lower Salem proposed to delete it completely.
Chair, if you go to section 29 of the 1997 Constitution, 27, sorry. Honorable Chair. Honorable Chair. Honorable Chair.
Yes.
Yes, section 27 of the Constitution, right to marry. 1. Men and women of full age and a capacity shall have the right to marry and found family. 2 says, marriage shall be based on free and full consent of the intent parties. Honorable, yes. Honorable Chair, these provisions is infringed. Yes, you can't do that. Honorable Chair. Honorable Chair, give me the time. Honorable Chair.
Order, honorable members, order now. Lower Salem, if you finish, we go to Pakala. Upper Salem.
No, what I'm saying, if you read the clause, provision 27, 2, section 27, 2. Yes, and now in these provisions here is that what is started.
Now, because I may be
now the lower Salem proposed us to delete sub 2. Yes, member for Upper Salem, can we hear you?
I think, Chair, now, Chair, this is the best clause in this bill. I'm telling you. You see, wait, Chair. No, wait. No, it's very good. Look, no, if members are talking from experience, I'm not talking about that. You know, if you see, Chair, the section he read in the Constitution, right to marry is a fundamental right. There's no question about that. But right to induce, falsify, knowing that what is in your mind is not going to happen. This is very good. We need to live it here. It's very good. And I talk from experience.
Man, there is a proposal from member for, okay, Willis.
Me now. Order. Chair, you know, the fear here is that you have many men who will follow underage girls and in fact give them money and promise to marry them when they are going to school. When they grow up to become women and they can decide on their own, they say, no, I'm not interested in the marriage. Then you come and call that seduction and say, all the money I have spent on you since we talked, you are going to pay it back. They do that. So you should be based on consent at the time of marriage,
see,
not before marriage.
Honorable Member Willis, I agree with you that this one should not be applicable because, in fact, at the time, the girl or the man was not in his. So therefore, this kind of law should not be put here.
Chair.
I want to support the submission of Willie that time the person might not be matured enough to decide by herself. So basically, I think to delete the entire.
Chair. You see, Chair.
No.
Chair. You know, you see, if you are doing, Chair, if you check the Women's Act, the Women Amendment Act 2015, and you check the Child Act, you understand, and the Constitution, that's even doesn't allow these provisions to be captured. Let's delete it totally. 90, we delete it totally.
Honorable members, it is proposed that clause.
I don't care. Allow me to make my presentation.
Yeah. Actually, no, just,
allow me to come, please.
I just want to bring the debate to add to it. It's under the section of Christian marriages. So under Christian marriages, you know, they announce bans of marriages, which are announced for a specified period. So if you look at the chapter or the area, administration of Christian marriage, part 2. Yes. So, and you see all these follow. And then you realize that, you know, they would have pronounced, they would have made announcements of bans for a stipulated period, which is mandatory in the church and so on. If you look at,
He said this section deals with Christian marriages.
Yes. So if you go to 84.
84.
Yes.
Book to enter publication of ban.
Yes, if you go to 84, even there is a book to.
Wait, book to enter publications of bans.
Honorable members, the advice I'm getting, technical advice on a legal point of view, it should be deleted.
Chair.
But there, no, yes.
Chair.
Not debate, but
Chair.
It's just for us to understand the context.
Yes.
Yeah,
Then
kindly
we can make
tell
the
us why.
decisions. Yes. Yes. So in those cases where they would have advertised in the church and then they document this. You know, if you look at it, they document it. They have a register to announce who and who should get married in 3 months. It's all announced. So those are, maybe it's discouraging those so that anyone who is not going to be serious about it will not go and make those announcements and so on. But if you look at the 191, it's even indicated a person shall not institute legal proceedings to compel another person to celebrate a marriage. And then 2 say, notwithstanding subsection 1, notwithstanding that a person should not take legal action, but also a person may institute legal proceedings to claim damage. And finally, as I rest my case, Chair. No,
Chair, I mean, I'm not convinced.
Let's look at it from both angles.
Minister, I'm not convinced.
Both angles. Yes.
No, go get it.
Yes.
No, you get it.
Yes. Yes. Yes.
But Honorable Chair, no Chair, let me come.
Now let's wait. I'm going to
No, Chair.
Then to open your mic, then we vote.
No, Chair, no, before you go, Chair.
Yes.
No, the issue is I'm not convinced by the minister. You see, if for this law,
No, this should not be there.
let me come.
Let me help you. Upper Salu. Lower Salu. This one should not be there.
Very well. No, Chair. No, let me come. Let me land. Chair, let me land, please. The minister doesn't convince me. You know why? Because if you are making law, you don't target a particular section or ethnic group. You understand? This law, even the Muslims can use this law against. No, allow me to come, please. If you are doing clerk, you are disturbing. Honorable Chair. You see, if you are doing legislating a law, you don't target a particular section. You see, this law, because there's nowhere it mentioned Christian, it is a law, it's general law. Even the Muslims can use it against other Muslims. Let's delete it completely from section 90. Let's delete.
I said Birkama no, Banjul no, but I have a proposal from Fonye Councillor to delete 90 sub 2. Yes. And then I'll go to Banjul North and come to you. Are you still okay?
Yeah. For me,
Banjul North,
yeah.
Opanyomi, their majority.
Thank you very much, Chair.
Yes, sir.
Chair, for me, what I wanted to know, you said you received advice from the technical team. So they said it should be deleted. So I just wanted to know the reason why, because you cannot just say, yeah.
Thank you. Open your mouth.
Honorable Chair, I am with the conviction that this is the best law so far we have ever received in this parliament. We have been men going around promising women that you are going to marry them and you fail them. Let's have a law in place. Let's discourage them. This is the best law so far. For me, I'm in full support of this particular provision.
Order, honorable members, order. You know, it is not saying male or female. It just it can be anyone. And I will go to Kantora, then Basse, and we.
Yeah, Honorable Speaker, I want us to look at this thing with all seriousness. It says where no proceeding may be taken, sub 2, notwithstanding section 1, a person might institute legal proceeding to claim damages or breach of promise to marry. Yes. There are promise to marry, seduction, or other goods cost. Is, for instance, now my understanding to this clause: if you promise an individual, let's say a man promised a woman, I'm going to marry you, and the person has now used his resources to spend on you, probably help you build a house, and then I'm coming. Let me just learn. So probably the person is claiming the compensation of damage you have incurred on the promise he or she made to you. However, fears to be allayed. This is already captured under common law. It's punishable offense. So whether it's here or not, it doesn't really matter. Gambia is part of the Commonwealth, and it's captured under common law. So please, let's just delete it and then allow it to be under common law.
Chair, I'm in line with Lower Salum. Chair, I'm in line with Salum. This section should be deleted because the reason why the explanation by the minister. Hello. The explanation given by the minister. Today he is there as a minister. Tomorrow he will not be there. And yes.
I'm in receipt of 2 proposals. Order, honorable members.
Chair,
I am in receipt of 2 proposals.
Chair, you give me the floor.
Yeah, I took it back.
Okay, thank you.
Okay. Honorable members, I am in receipt of 2 proposals. One from the member for Fonyi Councillor proposing the deletion of sub 2, 90 sub 2. This one from the member for Lower Salum proposing, order, honorable majority leader, proposing the deletion of the whole section 90 and its subsection. Now, because order, honorable members, we are going to start with the Lower Salum because once it succeeds, then there is no time wastage in going in. It is proposed that section 90 of the bill be deleted as proposed by the member for Lower Salum. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Chairman, please. I'm coming. Please, Lower Salum, just wait.
Division.
Please.
Division.
I'm with you. Just wait.
No.
No, wait, please.
No, division. Division.
Let him not delete. Delete the section 1.
Now let's do the procedure. Order. Now there is a procedure. Let's complete the procedure.
No, section 1 is important. It says
members. Wait. Section 90. It's saying that you cannot force a person to marry you.
To celebrate marriage. To celebrate a marriage. You cannot force anybody to say that you must celebrate a marriage. It says a person shall not institute legal proceeding to compel another person to celebrate a marriage. That's that if you marry now, that, okay, you have to go and rent a hall. No, no, just come in. It is good. It's good. You cannot compel your couple that you must celebrate your marriage. Honorable members, honorable members, honorable members, let me talk to the member for Upper Salem, Lower Salem. You know what is clause 1? I'm asking, wait, if you would want to amend your proposal, because clause 1 is saying, where no proceeding may be taken. Order, order. You will go back to Nyomi now. It says, member for Lower Salem, are you following? Number, clause 90 says 1. A person shall not institute legal proceeding to compel another person to celebrate a marriage. It's relevant. I want to appeal if you can amend that we did it only to sub 2. Use your mic. You are withdrawing. Thank you. Now we go to the proposal by combo by phone councillor to delete sub 2. It is proposed that sub 2 be deleted. Those in favor, please say aye.
Aye.
Those not in favor, please say no.
No.
The ayes have it.
Division.
Sub 2 has been deleted. Division, there is a division. Those in favor of the deletion of sub 2, raise your tax. Those not in favor of that, those abstaining, the results are as follows. Ayes 9, noes 8, abstention 2. The ayes have it. Okay, the count is not correct. Members, we are protesting the result. The result is not correct. Has been deleted. Honorable members, clause 91. Let's move.
Clause 91, time for marriage.
Yeah, no, he's not voted with you people. Close. Look at him. Minister, you know, he destroyed your case and now he's voted with you. Clause 91. It is proposed that 91. Okay. Member for
If you look at 91.4, second line, kept by, you will see Article A there. That A should be removed. Yes.
Where? 91.4 by A. There is him, by him or her. It is proposed that clause 91, time for marriage, stands part of the bill with amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk will proceed.
Clause 92, original register open for inspection.
Clause 92, original register open for inspection. It is proposed that clause 92, original register open for inspection, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 93, obliterating the original register.
Clause 93, obliterating the original register. It is proposed that clause 93, obliterating the original register, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. 94.
Clause 94, certain offenses declared to be misdemeanors.
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 It is proposed
Chair.
that clause 94. Yes, Kiangwes?
Clause 94B suggested a punitive measure for a penalty for the conduct above with an imprisonment term of 6 months and a fine of 5,000. That is a serious mismatch with the imprisonment time of 6 months and 5,000 fine. So I don't know, the legal may have a. No. If you look at
Honorable members, it is saying not exceeding 6 months and not exceeding 5,000. It can be 1 day prison. It can be exactly 6 months prison. It can be a fine of $10 or $1. It's not corresponding. That's what the member for Kiangwes is saying. Is misdemeanor. I think it's okay as it is. Because you know these are misdemeanors. Then it is just I don't know, you solemnize a Christian marriage. No, you know the jail term is saying it cannot be more than 6 months. That's what the jail term is saying. It can be 1 day, 2 days, 3 days. Or maybe 2 months or 3 months. Maybe we can say not exceeding 3 months. Are you following? Maybe we say not exceeding 3 months and not exceeding 5,000. Is that okay? 3 months, huh? Not exceeding 3 months and not exceeding 5,000. Okay, that's okay. 3 months. None. It is proposed that clause 94, certain offenses declared to be misdemeanors as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, you may proceed.
Clause 95, correction of errors in register.
No. Clause 95, correction of errors in registers. It is proposed that clause 95, correction of errors in registers stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 96, service of document.
Clause 96, service of documents. It is proposed that clause 96, service of documents stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 97, offenses.
Clause 97, offenses. Yes, member for Woolies, you don't have anything here. Huh?
I said the same. There is in clause 97(2), second line, where is the offense and is a liable. That article.
And is liable.
Yeah,
and is a liable. That A should be deleted.
Yes.
It is proposed that clause 97, offenses as amended stands part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it.
Clause 98, penalty for forging certificates.
It is proposed that clause 98, penalty for forging certificates stands part of the bill. Those in favor, please say aye. Those not in favor, please say. Yes, Woolies, Kiangwes. Kiangwes, 98.
Okay. Penalty for forging certificates. If you look at it, is it has specified that the person is liable to a conviction, which is not a
Less than 1 year.
Sentence term is not been specified.
No, the sentence term must not be less than 1 year and not exceeding 2 years. It's 1 year plus.
All right, thank you.
It's 1 year plus, or to both fine and imprisonment. Is that okay? It is proposed that clause 98, penalty for forging certificate, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it, clerk.
Clause 99, unauthorized disclosure of information.
Clause 99, unauthorized disclosure of information. It is proposed that clause 99, unauthorized disclosure of information, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 100, forms.
Clause 100, forms. It is proposed that clause 100, forms, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 101, regulations.
Clause 101, regulations. It is proposed that clause 101, regulations, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 102, repeal and savings.
Clause 102, repeal and savings. It is proposed that clause 102, repeal and savings, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. 17 March 26.
Motion.
No. How about the schedule? How about the schedule? Schedules. Schedules.
Chair. Chair.
Schedules.
Chair.
Schedule, wait, schedule.
Schedule 1, particulars to be entered in the register of births.
I don't know why. Honorable members, on schedule 1, you know where is missing? Of the father where applicable. Of the father where applicable on F. Add where. Of the father where applicable. It is, and then D, yes, minority leader. Of the mother. No. You know, it's a continuation up to F. Oh, okay. Forename, surname, birth name, address, and occupation of the mother.
I and J.
Where necessary, where applicable.
I and J. Already J has it, but I doesn't have. Should have where applicable.
Okay, and then I and J. Where applicable.
Yeah.
I doesn't have where applicable.
Yeah.
Chair. 78, appeal form refusal.
It is proposed that Schedule 1 as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Schedule 2.
Schedule 2, particulars to be entered in the register.
Schedule 2. It is proposed that Schedule 2 be part of the estimate of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Schedule 3, particulars to be entered in the register of marriage.
It is proposed that Schedule 3 stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Schedule 4, particulars to be entered in the register of divorces
Schedule
and
4.
annulment of marriages.
Why don't we say all the schedules, right? And the forms? Huh? We can say all the schedule and forms. Yes, can. Go ahead. It is proposed that all the schedules and the forms as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. The assembly now resumes. Yes, as we amended, just as marriages, no masjid. No, it's on the schedule. We said as amended. He said instead of masjid.
Page 60. Go to page 60. The Muslim marriage should be at the masjid. Just say remove it and put any place. Not every marriage is at the masjid. Page 60. Go to page 60. I have two. That's one. On 78. No, don't put any place there.
But if you say
at the place where the marriage is tight.
That's what I'm saying. If you
Yes.
say on that there's at
any place where it's tight, they put it there.
So that's we mention the place.
Yes. Now 78. You know, if you go 78, it say appeal from refusal now. An appeal shall lie within 30 days to the chairperson of the Kadi appeal panel. There is an established Kadi appeal panel against the refusal by a register of the Kadi appeal court. There's nothing like Kadi appeal court, it's Kadi court.
That we amended all in the bill.
That wherever it appears, it's Kadi court.
No, we did that.
No, wait. Wherever it appears, Kadi court. Okay, that's fine.
The assembly now resolved.
Chair, there is a problem. There is a little problem. Yes. So you see, you are right.
Yes.
So now, see these levels. There should be no appeal.
Yes.
It should be carried court.
Carried court.
Now, when there is a problem,
is the appeal panel.
Then the appeal panel.
Yes.
Which is there.
What the committee recommend is wrong. Is the Kadi court.
Order,
Not the Kadi appeal panel.
honorable members, order. Now, what we're going to do is the majority leader will move a motion to rescind our decision on the Kadi appeal courts.
Yes.
And then we leave it to Kadi court. We delete the appeals. Move that. Go ahead, move that.
I move a motion that rescind decision on Kadi appeal panels to read as Kadi court. Yes. Yes. There is nothing. I'm coming. There is nothing like Kadi appeal panel.
You know, if we change it to Kadi appeal panels, it distorts the whole bill. So it should be Kadi court. They wanted to say Kadi court and they say Kadi.
If you refuse at the Kadi court,
majority leader.
Okay,
Please,
okay.
I've taken the mic from you. Now instead of Kadi appeal courts, it should be only Kadi court. So we delete the appeals. Any seconder? Yes.
Honorable Chair, I second the motion.
It has been moved and seconded that where it appears as Kadi appeals court or panel, the appeals to be deleted to now read Kadi courts. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. The assembly now resumes. Honorable members, the House now resumes. Order, honorable members, order. Honorable members, I will now call on the Honorable Minister for Health to report to the Assembly what transpired at the Committee of Supply.
Thank you very much. Honorable Speaker, I report that the bill entitled the Civil Registration and Vital Statistics Bill 2026 have gone through the Committee of the Whole Assembly with or without amendments under the report of the Committee of the Whole Assembly on the...
Honorable Minister, what have transpired is with amendment.
I take it again. Just a second. Yes, I think. Okay. I think there is a missing page. Thank you, Honorable Speaker. I apologize for that. Honorable Speaker, I report that the bill entitled the Civil Registration and Vital Statistics Bill 2026 has gone through the Committee of the Whole Assembly with amendments, and that the report of the Committee of the Whole Assembly on the Civil Registration and Vital Statistics Bill 2026 has been be adopted. Thank you very much.
Thank you, honorable members. I'll now put the question that the report of the Committee of the Whole Assembly on the Civil Registration and Vital Statistics Bill 2026 be adopted. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable members, in accordance with Order 73, Sub 4 of the Standing Orders, the bill is hereby referred to the Assembly Business Committee for scheduling of the third reading. However, before this date, the Office of the Honorable Minister for Health and the Office of the Clerk is hereby urged to comply with Standing Order 73, Sub 5, to ensure that the amended version of the bill is printed and circulated to members in advance. Honorable members, thank you very much. It has been a very good day. The Honorable Minister and his team, since the weekend, have been engaging with members of Parliament to ensure that a rigorous work is done only for the interests of the Gambian people. I want to thank you, Honorable Minister, and your staff and members of the National Assembly. Honorable members, be it resolved that this August Assembly to stand adjourned until Monday, 23rd March 2026 at 10 a.m. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. The Assembly now stand adjourned until Monday, 23rd March. Monday, 23rd March. Please order, honorable members. 2026 at 10 a.m. Thank you.